morning.
Good morning.
Will you tell us your full name and spell your last name, please?
Bruce Eric Ferris, last name Ferris.
Mr. Ferris, what type of work do you do?
I'm a licensed mental health counselor.
And how long have you held that position?
I've been doing that for 14 years. I've counseled individuals I just recently counted 1,000 clients, not including group work I've done. I also am a consultant in domestic violence and testify as an expert court witness in domestic violence.
Let's talk about your education for a minute.
Okay.
Please enlighten us.
I have a Bachelor of Science degree in civil engineering. I graduated from the Police Academy in Gainesville, Florida, and I have a master's degree in mental health counseling.
And do you have any specialized education or training in a specific field?
Yes. Been to a lot of training seminars and certifications and various conferences. In my curriculum vitae, I'll call it a CV, my resume, there's about 100 items listed of trainings that I've been to over the years.
For what specific field?
In domestic violence and mental health and trauma to children and trauma in general, and I could go on, but that's the general focus of all my work.
Let's talk about your work experience for a moment.
Oh, okay.
Tell us about it, please.
So as a counselor now, my day is spent seeing individual clients. I specialize, like I mentioned, in domestic violence victimization, both men and women. I also see generalized mental health issues and typical things that a counselor would do, but I have a focus on domestic violence and family problems. I also counsel adolescent boys, most of which are going through the foster care system or adoption or divorce of their parents, etc.
All right, and what position did you hold prior to that?
I was a police officer in Gainesville, Florida for 20 years. I graduated the Police Academy in 1993, got sworn in 94, and I retired in 2013. The last 10 years of that career, I was a detective, uniquely running, I was a lead detective of what's called the Domestic Violence Unit of the Investigations Bureau at the Gainesville Police Department. Over the course of that time when I retired, I looked back and did a little search, and I had arrested or filed charges or got warrants on 500 different abusers over those years.
Mr. Ferris, give us an idea of your professional credentials. Likely.
Sure. I'm licensed with the state of Florida, like I mentioned, as an LMHC or licensed mental health counselor. I have to keep up with education, et cetera, keep my license active. I'm certified as a Batters Intervention Program facilitator. But in case anyone doesn't know it, Batters Intervention, which I'll refer to as BIP, is a 6-month class given to abusers who were found guilty or on probation or could be part of their injunction order. And it's a curriculum based upon the Duluth Power and Control Wheel. And it's a psychosexual type, not sexual. It's a type of therapy that involves some counseling and some ownership and learning. And also I was a certified police officer, I mentioned. I also have certification as a domestic violence danger assessment and level of danger scoring system developed by Jackie Campbell out of Johns Hopkins University. And I also have a certification as adoption competency training, mental health for mental health professionals out of Rutgers University. I'll stop there.
And briefly, have you been the recipient of various awards and recognition?
Yeah, I have.
Give us a brief idea.
Okay. The Alachua County Board of Commissioners had nominated me to Governor DeSantis to be part of the Children's Trust Fund of Alachua County. I received the 31st Annual Martha Varnes Award for outstanding achievement in prevention of domestic violence against women. I had recognition for valuable contributions in what's called crisis intervention team. I train officers how to de-escalate confrontations with citizens. I did receive the 2010 Distinguished Victim Service Award for recognition of outstanding contributions to crime victims for National Crime Victims Week by State Attorney General Pam Bondi awarded that to me, and Governor Scott at the time was there for the presentation. I'll stop there. There's a few more.
Have you been recognized as an expert on domestic violence in various courts of the state of Florida before?
I have.
Approximately how many?
So I've been involved in 60-some cases as either consultant or expert witness. 50 of those I've been recognized by the judiciary as an expert in domestic violence, mental health, batters intervention, effects of DV on children.
All right, and when you say you've appeared before approximately 60 times as an expert witness, was it for any particular side in a dispute? That is to say, for example, in a criminal case, was it always for the prosecution, always for the defense?
Both. I worked for the state attorney's office and worked for defense, and a majority of my cases have been in civil court, though I have worked in criminal court also.
Would you, Mr. Ferris, tell the ladies and gentlemen of the jury what another definition of domestic violence is?
Well, so there's the criminal statutes of domestic violence, which are typically, we all know, is battery, assault, ag assault, false imprisonment, sexual abuse, et cetera, person crimes involving a family or household member against each other. And that has another definition. That's spouses or family members living together, or it could be a couple that had a child together that have never lived together. It doesn't include, let's say, cousins who've never lived together and aren't intimate in any way. But through my experience, I've realized that there's a greater, that's umbrella, and that has to do with power and control. the abuser needs to control their victim. Now, they'll use the criminal things, hitting, et cetera, all those things, but in a greater sense, there's also this, I referenced it earlier, the Duluth Power and Control Wheel that DCF's accepted for the VIP class. I'd like to explain the Power and Control Wheel, if that's okay.
In fact, with the court's permission, we could perhaps have the screen come down and the lights dim. Mr. Ferris, you have a laser pointer in front of you. The little star in red will provide you with
Okay.
the dot.
Judge, may I stand here and pay attention to the mic as I talk? Any objection? Okay. So as I mentioned, there's the criminal definition.
Was there a question? Objection. Was there a question?
Go ahead. The question.
Yes. What is it that's on the
Right.
screen?
So what
Mr. Ferris?
Okay,
Mr.
so
Ferris,
yes, sir.
would you please tell us what is on the screen?
I will. So this is what's referred to as the Duluth Power and Control Wheel. And so there's physical violence and sexual violence. Those are the criminal things I talked about. And then there's these power and control aspects. And the nature of the power and control is repetitive. It's a way to get control. So up at, we'll call it 1 o'clock, using intimidation, making her afraid by using looks, actions, gestures, smashing things, destroying her property, abusing pets, and displaying weapons would be an aspect of intimidating your partner, again, to gain control. Using emotional abuse, putting her down, making her feel bad about herself, calling her names, making her think she's crazy, playing mind games, humiliating her, making her feel guilty. Then isolation, controlling what she does, who she sees and talks to, what she reads, where she goes, limiting her outside involvement, using jealousy to justify actions. Then a big one that I see often is minimizing, denying, and blaming, making light of the abuse, not taking her concern seriously, saying abuse didn't happen, making shifting responsibility for the behavior, saying she caused it. Another one is using children, making her feel guilty about the children, using the children to relay messages, using visitation to harass her, threatening to take the children away, male privilege, testing, treating her like a servant, making all the big decisions, acting like the master of the castle, being the one to define men's and women's roles. Using economic abuse, preventing her from getting or keeping a job, making her ask for money, giving her an allowance, making her ask for money, not letting her know or have access to family income. And the last one is coercion and threats, making her carrying out threats to do something to hurt her, threatening to leave her, saying that he'll commit suicide, reporting her to the government, making her drop charges, making her do illegal things.
I have a couple of questions I'd like to ask you about that wheel that you
Sure.
demonstrated for us. Is this something that you created?
No, this was created by, up in Duluth, Minnesota, there was a domestic violence advocacy group and also researchers, and they looked through police reports, they interviewed victims of domestic violence who come through the shelter, and through a period of time, they developed these 8 items and created the Power and Control Wheel. This wheel is used around the country and actually internationally. Like I said, it's the base curriculum for the Batteries Intervention Program class I talked about, and it's taught quite readily all across America and used by domestic violence shelters, etc.
How long has this wheel, if you will, been in existence?
Yeah, probably, I'm guessing 30 years or so, could be a little more.
Are there any agencies within the state of Florida that predicate their decisions
Yeah.
upon the Duluth Power Wheel?
Yeah, the DCF accepted the Power and Control Wheel for the curriculum for the VIP class.
That's the Florida Department of Children's and Families.
They were the ones who were controlling the VIP class when it started up. Also, a lot of federal money, domestic violence, against women act, things like that have always promoted the Power and Control Wheel, and also, giving out grants and education money.
Are the majority of abusers male or female?
Majority are male, but there's certainly a percentage that are female. I'd say it's at least 2/3 male at the least. And in my practice, I have male victims.
And what about on the other end, the victims of domestic violence? What's the percentage of males and female?
So again, there's some different statistics. Somewhere between 2/3 and 3/4 are men, and
Are men as victims of domestic violence?
2/3 and 3/4 abusers. So on the other side of that, they're 1/3 to 25% male victims. And I just got a male victim this past week.
Okay, so
Okay, I'm done.
I want to make sure we're clear on this.
Sure.
You've told us that the percentage of abusers that are male is approximately 2/3, is that
At least
correct?
2/3. There's some statistics that make it actually higher.
Would you tell us, please, what percentage of domestic violence victims are female?
Somewhere between 2/3 to 3/4.
All right. Now, I want to ask you if you would educate us, Mr. Ferris, about whether or not there are common characteristics that abusers share.
And I certainly can do that, Mr. Teller. Can I make one closing statement about the Duluth Wheel and
Sure.
Power and Control? So I think it needs to be said, maybe I didn't say it, that the whole idea of the use of the wheel is to get compliance by the abuser with their victim. So they're looking to control them, and either they use those criminal, the battery, or they use emotional abuse, or intimidation, or these different techniques to try to control them. So the victim of domestic violence is placed with wanting to have the least harm to them. So they get into a compliance, I call it equilibrium type of status mode, where they seek to get along, to go along. They don't want to poke the bear. They don't want, they believe that this is certainly a danger to be involved with this person, their mate, their spouse, etc. So they comply, and they get in this compliance mode, and they can certainly appear to society that nothing's going on, but there actually is, and they're afraid to display that because of the retribution that might happen.
All right,
I'll go on from there.
this wheel then is the product, if you will, of the science of domestic violence over the past 30
Right.
years.
And throughout my entire practice, the thousands of people that I've counseled, and even the 500s I arrested, I see this repetitively to be true.
All right. Now, would you please tell us,
I do. Thank you.
I need you to make sure you keep your voice up so the
Yes,
others
sir.
can hear you. Would you now tell us, Mr. Ferris, whether or not there are common characteristics that abusers share?
They can be anyone from all socio-economic stratas, and that's been my experience also. And I said, like I said earlier, predominance men, but also females.
What's the motivation for their behavior, abusers?
They want to control their partners. I find often an ownership type attitude. They want to control them.
How do they treat generally pets in the household?
Pets. So statistics have shown that abusers abuse pets well above average, more than average citizens would. And so I have two theories about that. One is that they're missing some empathy, or they tend to see things as objects. And so,
Objective, non-responsive.
okay. Can I explain why they abuse pets?
Yes.
So if a pet belong to the female or their partner, the victim.
I'm going to object.
Can you approach, please?
Mr. Ferris, would you describe for us what the term coercive control means in a domestic violence
Sure.
relationship?
So coercive control, acts of aggression, assault, threats and harm, punish, frighten the victims. And that fits in with creating fear, and it fits in with this whole continuum of power and control, a pattern that is developed to control the victim.
Do offenders always behave violently, or does the abusive behavior happen in cycles?
They don't always act violently in what common term of a battery or an assault. It can be accomplished just by threats and fear. And in terms of a cycle, there can be a violent or emotionally abusive state, and then a honeymoon side of state, and then it cycles back. In the field, we talk of a model of kind of like rain and sunshine. And,
All right, and let me ask you, Mr. Ferris, does the victim always appear to be afraid or act like they are afraid of the offender?
Definitely not. Oftentimes, the motivation is to hide the abuse from friends, family, law. There's lots of repercussions if it's disclosed. One could be fear that the oppressor, the abuser, the husband, the boyfriend, the wife, whoever's the abuser, will harm them. So they're very scared. The other is they might not even understand that they're victims of domestic violence. Quite often, when I get clients, people don't know those definitions.
How common is it, Mr. Ferris, for a victim of domestic violence to smile and act happy in the company of the abuser?
Very much so, and also in terms of even in public or with family.
Why?
Because they're afraid. They found this least resistance. They're trying to not poke the bear, as we'll say, or we've all heard the term walking on eggshells. They're trying to avoid aggression by their partner because they've grown to believe that there's a threat here.
So could we characterize that as an appeasement?
Totally appeasement. It's something I see quite often. And if
What
I'm
is the victim trying to accomplish by engaging in the appeasement behavior?
not encourage him to be abusive to herself, or if there's children involved, she's putting up a front to again create a type of stasis or minimum amount of aggression. So they don't want to again poke the bear. They're afraid of the repercussions.
All right, now give us some insight into this, if you will. Does the introduction of a child change these dynamics at all?
Yes.
Tell us how and why, please.
Okay, so it definitely ups the ante. We'll speak.
Objection. I have the same objection. Just at the bench.
I'll overrule on this one.
So yes, definitely, if someone is single and they're being abused, certainly they want to incur least amount of abuse. But when a child's involved, now they're concerned, and if they have a strong maternal instinct, now they're concerned about their own safety and their child's safety. And abusers will use a child as a manipulation tool to try to get at the victim. So the victim, that's even a further degree of way to pacify. Oftentimes women will stay in marriages because they want to protect the child even though it's detrimental to themselves.
A couple of questions about abusers, if I may. how do they generally rate on the scale of ability to charm and deceive others?
Quite highly. Those 8 years I taught domestic violence crimes, I got to know quite a few, and some were individual therapy clients also. Many of them, I used to say, have the gift of the gab. They were very personable, friendly. Not all of them, but a large percent definitely were very much the charmer. They'll hide the abuse, and they use it as a strategy to influence or control their victims.
Is there a pattern, excuse me, is there a pattern, Mr. Ferris, of denying, rationalizing, minimizing, or blaming the victim in these relationships?
I can say a very high percentage, well, I don't know, over 90% I'd estimate, of all my cases involve minimizing, denying, blaming. In fact, on the power and control wheel, I guess it's gone, it's one of the 8 categories is minimizing, denying, and blaming. And it's all a technique. Like she made me hit her. I didn't really do it. It wasn't that bad. They're always trying to minimize and talk their way out of their being abusive.
Would you explain to the ladies and gentlemen of the jury, Mr. Ferris, is there a particular time in these relationships when violence is most likely against the victim?
Yes, very much. The most dangerous time statistically is when a woman or a victim of domestic violence is leaving their abuser, and if the abuser is there. There's a high fatality rate, high incident of danger to them. I've been trained in this in my evaluation with John Hopkins' work. This is a really dangerous time. As advocates for domestic violence, we oftentimes have safety plans. Those plans, part of those plans, you never leave.
Staying.
All right. I'd like to ask you, Mr. Ferris, if I may, a couple of hypothetical questions.
Certainly.
Involving the hypothetical abuser and the hypothetical victim. First, I'd like you to tell me, would the following acts be consistent with an abuser? And allow me to finish, and then you give your opinion.
I'm going to object to that.
All right. You want to approach?
Yes.
So, Mr. Ferris, I'm going to give you a series of hypotheticals, and I'd like you to tell us if it's consistent with abuse.
Yes, sir.
Shooting a gun in the kitchen of a home in an effort to intimidate the victim to stop speaking. Throwing the loaded gun at the victim. Cruelty to pets. Punching a dog in the face hard enough to knock the dog unconscious. Throwing a cat down the steps. Placing a tracker on the victim's car, an illegal tracker. Throwing things, breaking things, yelling, screaming, belittling, cursing, humiliating. Declaring such statements as rid the earth, being in a murderous mood, kill all the bad people, take them out, being caught at night, peering into windows of the victim's home, violating a no-contact order by sending a package, driving from South Carolina to Florida to be able to follow the victim, suicidal threats if the victim leaves, more than 30 years age difference, and finally, prior marital history whereby the prior wife explains how she was beat up on the honeymoon. Would that be consistent with abuse?
Absolutely. And not only absolutely, but those are checklist points right off the Duluth Power and Control Wheel, and right off my experience, they're stereotypical abuse techniques.
All right, and now my last question for you, Mr. Ferris, is I'm going to give you a hypothetical. And tell me if this would be consistent with someone who suffers from abuse. Sending texts that are conciliatory with friendly emojis, accompanying the abuser during child time sharing ventures, acting deferential and subservient in joint therapy sessions, but decisively different in individual sessions, fearful of the abuser finding out the victim described him as controlling, manipulative, and abusive, and being exposed to threats, intimidation, pushing, holding down, humiliating, cursing. Would that be consistent with a victim of domestic violence?
Without a doubt. These are, again, techniques of compliance, not wanting to poke the bear, walking on eggshells, trying to minimize harm to themselves and their children. They'll put up a front. They don't want anyone to know, and they don't want their abuser to be angry by them disclosing. So, yes.
Lastly, one other factor I neglected to mention. Would a video of the abuser and the abused at a restaurant with the child and another adult, whereby they are all acting happy, be consistent as well?
Well, certainly, if you're asking, they're acting happy, is she still a victim of domestic violence? Definitely, and it also fits with this whole idea of appeasement. We have to remember that the domestic violence comes in layers through the years of events. So one incident...
Judge, I'm going to object to non-responsive.
Overruled.
So that behavior isn't just a spot image right then. What's going on inside her? Why is she acting that way? That's what I would ask clients. That's what we're looking for. And if it's truly a victim of domestic violence, she'll be in this appeasement mode to try to please him and not disclose the abuse to get along sort of description.
My final question, as it relates in general to domestic violence. Assume, hypothetically, there were several violent or semi-violent acts of domestic violence, and then there was a break in the chain of events for, let's say, as much as a year or two, and then it started up again. Does the victim remember, and is the victim affected by the earlier acts of abuse?
Without a doubt. I've got clients who tell me about...
Sustained.
Yeah, just
So
academic.
yes, definitely, they don't forget the abuse that's occurred to them, trauma lasting. Adults remember childhood trauma, let alone something from several years ago. Like I say, layers of impacts of behavior.
Thank you very much. No further questions from Mr. Ferry.
State, cross.
Thank you, Judge. Good morning, Mr. Ferris.
Good morning.
Dr. Mr.
Mr.
Okay.
Oh,
I want to ask you give you some examples and ask you if this is consistent with a victim mentality.
sure.
Minimizing the abuse.
Now you're asking me if the victim would minimize?
Yes. Like, what I mean by that, and maybe I said it wrong, is like covering or taking blame for the abuse, covering for the abuser, taking blame,
Yes,
making excuses for him
definitely.
or her, I guess, but not reporting the abuse,
Right.
dropping charges if they were filed,
Yep.
not standing up for themselves,
Yes.
and not leaving.
Yes.
Okay. I'm going to put that wheel back up, and I want to talk to you about the pie sections each.
Sure.
Okay. Sorry, Judge. While she's fixing it, and I know you're familiar, and do you have a copy in
I
front
do.
of you?
I
do
want-
too.
I want
do
right in
too.
front of me.
Okay. And so I want to talk first about the use of intimidation. Would you agree that if somebody, this says making her afraid by using looks, actions, gestures, smashing things, destroying things, her property. We talked about a break. If those things weren't occurring for years, would you, but had allegedly occurred prior to that, would you still consider that part of this dynamic?
Yes.
If it's been a distance in time?
Yeah, I think the distance can be totally irrelevant.
And there's a section on here about the economic abuse. Would you find that if a hypothetical victim was living on her own for several years, had no monetary dependence on the alleged abuser, and lived in her own home in another state for part of that, and there was no monetary connection, that would not apply to a relationship?
Could you restate the question?
So if in this wheel,
Right.
hypothetically, when I'm talking just about using economic abuse.
Right.
Would you agree, would you say it still applies if the victim was living on her own for several years with family and independently sufficient economically? No financial dependence on the other person. Would you agree with me that economic abuse would not apply to that relationship?
From the scenario you give me, it doesn't sound like it would apply.
Okay. And for isolation, would you agree that if it's the same facts, living on her own for several years with family, so I know it says isolated from family, I think. Living on her own with family and having some periods of no contact for over a year, and then being back in contact, but living separately and having her own cell phone, having her own car, having her own home. Would you agree with me that that's not a situation where there was isolation?
Well, you have to remember, under the isolation also comes jealousy and justifying actions. So in terms of isolating, not letting their partner or the victim go to work or see family, in that sense, what you're saying is true. But a component of isolation could also be extreme jealousy, possession, your mind, those sort of things.
And I didn't add those facts. You're adding those facts, right?
Well, under the power and control world, the last item, I don't know if you actually mentioned it, using jealousy to justify actions.
And if that was not a factor, that's not a factor.
Then isolation component may not be part of that, component for that scenario we're looking at, the couple we're looking at.
And why do you say may not? What part of that would apply?
Well, it would not be.
Okay, thank you. Using the children. If the hypothetical victim had custody of the child and attempted to terminate parental rights, and the hypothetical abuser had to seek court intervention to get the child,
Right.
would that be a factor in your consideration of whether children were being used? if she had sole control of the child.
So you're asking me if I could just reframe it, that the alleged abuser is not, he's not using child against their alleged victim, then they're not necessarily guilty of using the children.
I'm not asking if it's guilty, I'm just asking if that would apply. We've talked about how these
Right.
things apply.
It may not apply, it would not apply, but I think if I could mention, you're missing the point of the power control wheel. This is about pattern of behavior.
I'm not missing it,
Okay.
I'm just asking hypothetical
Okay.
questions. How about the using a male privilege? If that hypothetical abuser was not having any control over her big decisions or did not live with her, so was not being the master of the castle, was not treating her like a servant because they lived separately, and was not defining their roles, in fact, was offering to purchase things, get her anything she needed, those kind of things. Would you agree with me if those were the facts of a relationship, male privilege would not apply?
No, I wouldn't agree with you.
Okay, can you elaborate?
Yeah, the men's roles, and when you say purchasing things, I would want to look into what is that a concept of what the role is. I'm the man, I purchase things, I control things for you, I decide what to get, et cetera. So that could be a male privilege issue.
Okay, and I understand that, and that was a poor fact scenario in mind. I think it kind of goes with the economic abuse, and what I should have asked is, if she's asking for, can you stop and get me boxes, or can you stop and get me tape, or can you stop and get me something else, and he is, yes, of course, and he does it. That's what I'm talking about, not him telling her what she may have.
So in terms of him buying things for her that she's asking for, I wouldn't consider that to be domestic violence.
Okay, you would not?
No.
Okay. And so that's, other than that caveat, then male privilege wouldn't necessarily apply to the cycle that we're in, under my facts.
The facts are not complete enough for me to come to the conclusion.
Okay. How about minimizing, denying, and blaming? What, you said that was present in 90% of the cases.
Quite a bit, yes.
Right.
Mhm.
I think you said 90.
I did.
What if the hypothetical abuser says, I was wrong, I lost control, I shouldn't have done those things, and never says it was your fault you did those things? Would you then feel like that's not minimizing, denying, and blaming?
No, I wouldn't agree with that.
Okay.
Because it could be that part of the strategy of minimizing could be that, I'm sorry, I didn't do it. That could just be minimizing.
I'm sorry, no, not I didn't do it. I'm sorry I did it.
Right.
That's part of
still-
minimizing?
Yes.
Well, certainly not denying or blaming, right?
I would need more definitive
I
facts.
guess I need an explanation on if somebody takes responsibility for accusations against them, how
Right.
that is minimizing. Just to say, yes, you are correct, and I am sorry.
It could be a way to dialogue or to minimize what occurred by accepting blame for it, and that could be part of their scenario.
Could it also be the opposite?
Yes,
That
it
person
could
is
be.
taking responsibility for their
Right,
actions.
certainly it doesn't deny that it happened, that's for sure.
Right. And no blame being set forward if they say it's my fault.
Well, just because someone apologizes doesn't mean they weren't abusive.
I'm just talking about the factors on this wheel.
Right.
And whether or not, if somebody's, under my hypothetical, admits to responsibility for the accused abuse and apologizes for that, whether or not you would consider that denying and blaming.
I would need more information on the relationship in the scenario to decide that.
Is there a scenario? Okay. How about using emotional abuse? If there's no accusations of any name calling or telling her what to wear, this hypothetical victim, in fact, she's comfortable enough to wear a sports bra and shorts around him. There's no displaying weapons. I'm sorry, I'm looking at the wrong one. No evidence in their relationship of playing mind games or humiliating her or making her feel bad about herself. Would you agree with me that that might not be a factor?
Well, you gave me a discrete list, but emotional abuse also includes name calling,
Okay.
putting someone down, affecting them emotionally.
I guess, is there a scenario, Mr. Ferris, where you will agree with me that a relationship might not include emotional abuse? Because I don't know how to give you enough factors for you to say, no, it may
Yeah,
not.
I can't help you with that. I'm not asking the questions.
Oh, I was asking you one. If there
I
was
know,
a
I'm
scenario.
not, you are.
Okay. Would you take into account, with these factors such as emotional abuse, economic abuse, male privilege, using children, all of these, if the alleged victim, or let me give you a scenario. She does not live with him. She's actually in another relationship, potentially engaged to a new man.
Okay,
She tells him that she does not want to be with him.
okay.
And she plans to move away without him. Would those be factors that you would have to take into account when deciding if that relationship fit this power and control?
Well, that would be factors of the relationship, but I haven't heard you say anything about what their history is, what trauma she's experienced, what's going on with children in their lives, all sorts of other dimensions of the relationship.
I guess, so is there no scenario where there can be abuse in a relationship and then there no longer is abuse, where they are no longer in this wheel? Because the way you're answering your questions, that's the impression I'm getting.
So I have come across situations where there's an emotional abuse or a physical abuse, but it's not a pattern of behavior. It doesn't go on over a period of time in an attempt to control someone. So if I may, if someone pushes down their girlfriend on a night out and he gets arrested for domestic violence because they live together, it's a battery, that's domestic violence, but that's it. He doesn't she's not appeasing, she's not put an emotion, the whole power control dynamic isn't happening. That is domestic violence under criminal law, but it isn't domestic violence in the sense of a pattern or behavior to try to get the appeasement or the sort of consensus out of a victim where they're afraid to poke the bear, all the things I've already talked about. So if that answers your question.
It didn't. Is it your testimony that once a relationship has these power and control aspects, that is forever, even if there's no continued allegations of abuse for years, no continued allegations of abuse, no continued allegations of emotional abuse, never any allegations of sexual abuse. The parties are living apart. They're independently, I keep saying independently wealthy, that's not what I mean, economically independent. They are, the female is telling him she doesn't want to be with him and has moved on to a new relationship. Is there no scenario, in your opinion, where people can get off this power and control wheel, even if they were on it at some point in the relationship?
I think it's possible, but it's not likely, and it's not the typical thing that I see. Usually there's still a dynamic of emotional abuse.
So even under my facts,
Yes.
with no allegations
Yes.
of emotional abuse in years,
Yeah.
it's your opinion that not good enough, they're still on this power
Well,
control?
I can speak from my critical learning and studying this, and also my practice, and I have custody issue couples where they're domestic violence, and 10 years later, there's still abuse taking place, even though they're remarried and don't live together. So by example, I see continued abuse. Could there be a couple that don't? I'll say it's possible.
Thank you. I don't have anything else.
Redirect.
Nothing further, Your Honor.
Can this witness be released?
Yes, sir.
Yes.
Sir, you are released from your subpoena. You're free to go.
Thank you for all your help.
All right, Mr. Taylor, call your next witness.
Gina Torsia, Your Honor.
Judge, I think we're going to have to approach. Thank you.
Good morning.
Good morning.
Would you tell us your full name, spell your last name, please?
Gina Torsia, Torchia.
Ms. Torsia, did you at one time work for an attorney by the name of Stephanie Murphy?
Yes, sir.
Back in June of 2018, would you have been employed under Ms. Murphy's guidance?
Yes, sir.
Do you recall exchanging an email with Detective Gillum on June 5th, 2018?
Yes, sir.
Did you have an opportunity to review it?
Yes, sir.
I'm going to pass to you, Ms. Torsia, what I've marked as Defendant's Exhibit number 25, and ask you if you can identify it for us.
Yes, sir.
What is it?
It's an email from Detective Gillum.
And does it include a response from you? Or is it a response to your initial email to him?
It's a response from my initial email to him.
Okay, and is it a true and accurate copy of your email to him and Detective Gillum's response?
Yes, sir.
Move to introduce it into evidence at this point, Your Honor, Defense Exhibit 25.
Same objection?
Yes.
Overruled.
All right,
Defendant Exhibit 25 will be received.
Ms. Torsia, did you on this day send Detective Gillum a copy of the South Carolina Domestic Violence Restraining Order?
No, because we were not aware of one.
Okay. Does he send you a copy of the order?
He does send me a copy of the order, but there was never an order entered into the Charleston County Clerk's or the Sheriff's Office,
Yeah.
so we had no proof of an order at the time.
Would you please read for us, Ms. Torsia, Detective Gillum's response to you on Tuesday, June 5th, 2018,
Gina.
6:19 p.m.?
I noticed something that you both need to be aware of, unless there's something I'm missing. If you read that section just before the judge's signature, it states the order will be in place 6 months of the day of the hearing, which was May...
Ma'am, can you slow down just a little bit?
Oh, I'm so sorry. I'm a fast reader.
Okay, well,
Sorry about
slow down a
that.
little bit for us.
Evelyn Wood School, huh?
Where do you want me? Okay.
6 months of the day of the hearing.
Which was May, November 3rd.
Ms. Torsia?
Yes.
I'm sorry. Would you start over, please?
Yes, sir. Gina, I noticed something that you both need to be aware of, unless there's something I am missing. If you read that section just before the judge's signature, it states the order will be placed for 6 months of the day of the hearing, which was November 3rd, not November 27th, and sets it to expire May 3rd, which would be 6 months from November 3rd. Again, it's not something I would have made a physical arrest on, but the SAO will at some point make a filing decision. If I am reading something wrong here, let me know.
Okay. We can agree that SAO would be State Attorney.
Yes, sir.
So, lastly, Ms. Torsia, this is Detective Gillum telling you that the order was in effect, the stay-away order,
Objection.
as of November 3rd, 2017, correct?
Objection.
Sustained.
This is Detective Gillum explaining to you,
Objection asked and answered. She read the email.
Sustained.
just a moment, Your Honor. Ms. Torsia, let me pass to you what I've marked as Defendant's Exhibit 26.
Can I see it, please?
So, Ms. Torsia, let me pass this to you. I want to see if this refreshes your recollection as to whether or not you sent a copy of the South Carolina order to Detective Gillen.
Yes, sir. Yes, this is the order.
Yeah, without referring to it, my question is only, did you, in fact, now that your recollection has been refreshed, send a copy of the order to Detective Gillen?
Yes, sir.
And then he responds to you a couple hours later with the email that
With-
was introduced.
Yes, and there's also
No
an,
further questions, Your Honor. Thank you, Ms. Torsia.
Any cross?
Can you finish your answer, please?
yes, there's also a predicament where Detective Gillum, there was no order entered into the clerk system in Charleston, and there was no order entered into the Charleston Sheriff's Office. So he had no bounds to make an arrest just based on this when it wasn't entered.
Sustained.
Ask to disregard, Your Honor.
Members of the jury, testimony regarding an opinion's witness about violation of criminal law is inappropriate, then you should disregard those last comments. Anything else?
That's sufficient. Thank you, Judge.
Read a rep?
No.
Can the witness be released?
Yes.
Yes.
Thank you, Your Honor.
Thank you, ma'am. You're released from your subpoena.
Would you like to? Thank you.
On December 6, 2019, that Ms. Benefield wanted to document the fact that her estranged husband admitted in a text message that he placed a tracking device on her vehicle in the past, that she has observed him driving behind her on multiple occasions, which concerns her, and she wanted this information documented. She brought her vehicle to a local auto dealer, but a tracker could not be found. Due to the fact a tracking device was never observed on the vehicle, an information report was completed. All right, any objection?
The objection, Judge, is that anything contained in this report, which the nature of this report, according to it, is information, but anything contained in this report is hearsay other than that Ms. Benefield physically appeared at TRU on December 6, 2019, because everything that Mr. Deputy Lindsay wrote down was told to him by Ms. Benefield. And so the state would object to his being able to testify to anything other than she appeared at TRU on that date, which seems irrelevant, if you remember.
Proponent, defense?
Yes, so it clearly goes to her state of mind at the time, and it also corroborates her defense. I do not plan to ask the deputy to read it. I'm going to ask him if he took a report from Ms. Benefield, what the date was, and whether or not it was her reporting about a tracker being placed on her vehicle. That's all.
And that's hearsay, in the state's opinion, Judge, because it's self-serving hearsay. It's actually hearsay within hearsay, I think. But if he wrote something and asking him what he wrote in a report about somebody else told him, but it's at least one level.
All right, thank you both very much. The purported reason for the introduction of this testimony, according to the defense, is to show the defendant's state of mind and that it corroborates her defense. Both of those sound to me like the introduction of this report to the sheriff's office regarding a tracker is being offered for the truth of the matter asserted that a tracker was placed. That would obviously make this hearsay. It's the introduction of an out-of-court statement to prove the truth of the matter asserted. That being that a tracker was placed on her vehicle, thereby corroborating the testimony that has already been provided. My notes are that it's already been testified to that the tracker was placed on the defendant's vehicle, and my notes are that she testified, or it's been established, that the victim in this particular case admitted that he placed it on her vehicle.
Yes.
So that's already in, and I think I said this the other day, and it bears repeating. So this is self-serving hearsay. It's clearly excluded. I will just note a secondary reason would be the relevance of this report. The issue is not whether or not she reported it to the authorities. The issue is not whether it's true or it's not true. The case law is very clear on this. It's not relevant whether law enforcement believed her or didn't believe her. the purpose of allowing these prior bad acts, and I say prior bad acts instead of going into all the different ways that can be done, but in a self-defense case, once the defendant has established there was an overt act, prior incidents of violence and intimidation and threats can come into evidence. The case law is very clear. They may be true, they may not be true. The issue is, what did the defendant know on the day that the force was used? And so those prior acts of the specific incidences of prior bad acts or prior violence don't have to have happened to her. She just has to know about it. And the tracker issue, while not necessarily violent, certainly it's intimidating. And I allowed it. I don't remember if the state objected or not, but I allowed that in. The testimony is in. Whether she reported it to law enforcement is of no moment. Whether it's true or not, because put it this way, the tracker wasn't found, so it was just an information report. It doesn't matter if it was found or not. It doesn't matter if this officer believed her or not. The issue is, it's something she's aware of. She testified to an overt act. It's already in evidence. So at this point, this is not marked. What was it? I don't even, who's the next person? What was his name or her name?
Lindsay.
That was Deputy Lindell.
Lindsay, Scott
Scott
Lindsay.
Lindsay.
It's on top of the report.
Scott Lindsay, I'm sorry. Lindsey.
So, I mean, you could call him, but the substance of her walking in, him taking a report, again, none of that is relevant to the issue of her knowledge of prior incidents.
That's all I was calling it for, so. Yeah.
All right, I do want to give you all a break, though. I know we started at 9, it's about 10:30, I think it's reasonable to go ahead and take a break. So, why don't you guys take 10 minutes?
Thank you, Judge.
Tell us your full name and spell your last name for us, please.
Vincent Vizzacaro, Vizzccaro.
All right, Mr. Vizzacaro, I'd like you to try to keep your voice up if you could.
Will do.
What do you do for a living, sir?
I'm in real estate.
And where are you a realtor?
Lakewood Ranch, Bradenton, and Sarasota areas.
Do you have any particular specialty?
Residential homes in Lakewood Ranch.
How long have you been doing that?
About 8 years now.
I want to ask you whether or not, back in 2018, you had occasion to deal with an individual by the name of Douglas Benefield.
Yes, I did.
Would you tell us the circumstances under which that relationship took place?
Yes, he contacted me looking for a
Objection,
home.
hearsay.
I'll overrule at this point.
Thank you, Judge. Contacted you looking for a home?
Looking for a home he was trying to acquire through a business that he said he owned in Lakewood Ranch.
All right. And back in 2018, Mr. Vizzacaro, did you use emails to communicate with him?
I did.
And did he communicate with you in the same fashion?
Yes, he did.
Were emails back then a normal and customary part of your business?
Very much so, yes.
Did you preserve the emails as they related to each client's files?
I do that, yes.
And were the emails under your care and custody?
Yes.
Mr. Vizzacaro, I'm going to pass to you what we've marked as defense exhibit number 27.
Can we approach Judge?
Yes. What I'm going to do is, at this moment, I need to do some research and speak with the attorneys. So I'm going to excuse you to the hallway. There's a thing called the rule of sequestration that has been requested by both parties. And that means that you cannot discuss your testimony or the questions asked of you with anyone else. You can't discuss other witnesses' testimony or what questions they were asked or what testimony they gave while here in court. Or do any research on the case, watch it, or anything else.
Understood.
All right, we'll call you back as soon as we can.
Okay, thank you. So Thomas v. State is helpful. It's 993 Southern 2nd 105 1st DCA. Although it was the state introducing the email against the defendant, the state sought to introduce an email that was prepared by an employee of the apartment complex where the victim lived and was murdered regarding statements made by the victim that she had someone living with her that was not on the lease for a year and she wanted that person out. And obviously the state was introducing that to prove that that was the defendant and that the victim was trying to evict him, and that was part of the reason why he then murdered her. And the first DCA found that even if the email from the employee's side qualified as a business record, and I don't see where they actually found and held that the email was a business record, which was my original question, but ultimately concluded that the statements that were made and then by the employee and then communicated through that business record, those statements were not, well, first they're hearsay, but they were not part of the records and the data compilations of the business itself. And that although hearsay may exist within exhibits that fall within an exception, such as business records, those hearsay statements must still qualify under a separate exception to the hearsay rule.
And in this particular situation, if I'm understanding correctly, what the defense is asking is to introduce Defendant's Exhibit 27 through Mr. Visicaro as his business record that he keeps. But according to Thomas, and then they also cited a prior case of theirs, Van Sant v. State, Vanzant, 372 Southern 2nd 502, Florida 1st DCA 1979. Even if this qualifies as a business record, which again, I have not found a single case that says it does or doesn't, and I don't see in my review of Thomas where it says it is or isn't. But the statements of Mr. Benefield are being offered to prove the truth of the matter that he's looking to buy a house in Lakewood Ranch are hearsay without exception.
But the exception, Your Honor, is his state of mind. It clearly shows Mr. Benefield, let's not forget what the defense is here. The court's allowed me now to bring in evidence of domestic violence, and here is Mr. Benefield, Judge White, negotiating with the realtor to buy the house directly behind the home where Ashley Benefield lives, and he's doing it at the time the South Carolina domestic violence injunction prohibits that. He would not be able to buy that house directly behind Ashley Benefield's home. It's like 200 feet away, 100 feet away. And it's a continued pattern and practice. That corroborates the defense.
Do you want to be heard on 90.8033, then existing mental, emotional, or physical condition?
Judge, his emotional, mental state, that it still has to be material to a material fact. And his state of mind at that time is not a material fact. Also, I think the defense is misrepresenting some of what's in the email. Mr. Benefield never said he wanted to buy the house. He said he wanted to rent the house, and he said, I'll have to check with Ashley first. So I think some of the misrepresentation that's going on, we should probably just read the email. But I don't think it has anything to do with his state, read the email. But I don't think it has anything to do with his state of mind. His state of mind at this point in time is not relevant.
He evaluated Ashley Benefield, and his testimony, which is the only testimony that's been brought forth in this hearing, was that at no time did he conduct an evaluation. He was not hired to do an evaluation. With respect to the state's statement about motive evidence, motive is not an element of the offense. However, self-defense is certainly a material element to be considered, and there is, according to the information that is discussed in the Supreme Court opinion, Your Honor, it is not, and decidedly not, a subject for lay testimony. They could not make it more clear that there are many aspects about domestic violence. In fact, the words that they use in the Supreme Court opinion is that judges and juries do not understand and would benefit from expert testimony. I would suggest to the court, drawing a distinction between Daubert and the case law on battered spouse syndrome, I would suggest that, given the facts of this case, an expert such as Bruce Ferris, who could educate the jurors on the impact of an abused relationship, domestic violence, in and of itself would be enough to provide expert testimony to counter the state's position and the issue that they raised about the go along, get along. I think it's clearly beyond the scope of lay people to understand that. And I think that expert testimony would help explain it. So Daubert, of course, doesn't apply any less under those circumstances. However, it would not be restricted to the extent the court wanted to draw such a narrow line and say, for example, okay, well, this is not battered spouse syndrome because for it to be battered spouse, you absolutely must have the abused party living with the abuser having had physical beatings. If the court wanted to draw a line that narrow, rather than include it under the umbrella of domestic violence, I would still submit to Your Honor that the testimony from Bruce Ferris clearly met the Daubert standard for admissibility, and I would call him as an expert witness on domestic violence. And if the court really wanted to narrow it even further, as it relates to a woman who would choose appeasement and go along, get along, coincidentally, like I think we had 4 psychologists testify in this case so far, and every one of them have used the same terms to describe this phenomenon. I think I need and I should be entitled to be able to explain that to the jurors, and I'm not going to be able to do that without expert testimony. So I think the state combines Daubert with the case law, and Daubert is the procedural vehicle for allowing expert testimony.
All right, I do have some questions.
Yes.
I end the week, kind of as I mentioned at the hearing we had regarding Mr. Ferris before the trial started, whether it was last week or the week before. On July 11th, at a hearing, you said this was not a battered spouse case. On July 12th, you filed the notice of intent to rely on battered spouse syndrome. What is this? Are you arguing battered spouse syndrome or not?
Okay, Judge, once again, I filed that notice with a footnote in the title, Notice of Intent to Rely Upon Battered Spouse Syndrome, footnote. The reason why I told the court this is not a battered spouse case is because technically, Your Honor, battered spouse requires those 2 elements. I shouldn't even say it requires those 2 elements. Those 2 elements are generally present in the battered spouse cases that we've seen. So in my footnote, I said, as it relates to domestic violence. So I wanted to cover both scenarios. I wanted to cover expert testimony to explain this phenomena under battered spouse as it relates to domestic violence, because it's the same syndrome as you've heard. It's the same mentality. Everything about it's identical. But I also felt, at the same time, entitled, upon meeting the Daubert standard, to just call an expert on that particular issue. And this expert's eminently qualified to explain that kind of behavior. So Daubert is, again, the procedural vehicle that qualifies whether or not the expert is capable of meeting the standard. And that would apply whether it was to battered spouse or just as domestic violence.
All right. So we've got the case law that we've all been discussing for the last couple of weeks regarding battered spouse syndrome, the notice that's required, why it's a carve-out, why it's allowed when Okendo doesn't allow PTSD, other cases don't allow significantly impaired intelligence, mental health issues. When I say mental health issues, I'm not talking insanity and so forth. I'm talking about diminished capacity, right? Essentially diminished capacity, because we're looking at a reasonable person. Do you have cases that do not use the word battered spouse syndrome? They use domestic violence victim of domestic violence, and that is allowed in self-defense cases.
Would it be any different, Your Honor, than a criminal case of culpable negligent homicide, the issue being the trigger pull and the weight that in order for the weapon to fire? And you're an expert to testify that the trigger in that particular gun was set to a particular level to try to explain to the jurors why that gun might discharge, and you're not necessarily negligent because of the discharge. Other weapons, if you banged against the wall, might not discharge. This one has a hair trigger. The defendant turned, hit the banister, the weapon discharged, shot and killed somebody else. If that expert met the Daubert standard, why wouldn't that expert's testimony be admissible to explain that? To try and explain to the fact finder, who would not have that knowledge, that indeed this could be nothing more than an accident that does not rise to culpable negligence, and therefore the charged individual is not guilty. And what I'm saying to the court is that evidence of domestic violence, if it meets the Daubert level, I should be entitled to defend and explain to them why she would engage in this type of go along, get along.
So the answer is no, you don't have a case.
I do not have a specific case on that point, no.